I'm Ruth Hughes. I'm a barrister at Fivestone Buildings and I specialise in mental capacity law. I often act for professional deputies and the official solicitor in property and affairs matters and some health and welfare matters. Okay, so one of the cases that I talked about in today's presentation was a case of E, where E had been the subject of a road traffic accident, and E had suffered a brain injury, and as a result he'd had a frontal lobe damage and he lacked capacity to manage his property and affairs, and he'd had a personal injury settlement. And the issue was whether or not he should be told about the sum of his award, because he was vulnerable to exploitation in his life, and he also suffered from stress to do with financial matters, and he had said that he thought it might be better for him not to know, and the court decided that it was in his best interest for him not to know. It was an unusual decision because it obviously, as a matter of logic, it was impossible for him to properly understand all the elements of the decision-making process for him to be properly involved in, because one of those things was how much he had been awarded, so it was sort of circular, but the court decided it was in his best interest not to know, and it was better for the court to make that decision rather than the deputy, because then the deputy wouldn't be the gatekeeper of the information, and if he asked, he could, which he would probably have done, he could be told that it was the court that decided that it was best for him not to know. So there are often typical fact patterns, particularly in statutory will cases. So you'll have a fact pattern which exists because there's a will that has been made which is vulnerable to challenge, for example, because of undue influence, want of knowledge or approval or lack of capacity, and the parties will be essentially trying to pre-litigate that contentious probate claim in the Court of Protection. Or you might have a case where you might call it a bad Samaritan case, where someone's come into P's life very late on the day and has been influencing them and taking gifts and payments and has a will in that person's favour. Or there's a typical fact pattern to do with a second family. I'm sure you can imagine what that fact pattern is like. And there's also the sort of fact pattern where P is intestate without close relatives, and it's not clear who ought to benefit from P's estate, but probably not the third cousins 8 times removed. So I think that it is important for deputies to get together and discuss things, as it's important to have practical and legal updates for continuing professional development. But I actually also think that it's really important for deputies to be able to get together and discuss the problems that have arisen amongst themselves, to kind of talk about practical issues and think about solutions to problems they have on the ground together, and I think that happens at lunchtime.